Working socially inconvenient hours, like Saturdays, Sundays, public holidays, or late night shifts, carries a hidden yet substantial financial risk. If you are a migrant worker, an international student, a temporary visa holder, or anyone working casually or part-time in Australia, this risk applies directly to you. Checking only the standard hourly rate on your payslip is a mathematically flawed way to determine your legal pay. There are 5 distinct categories of extra pay. Penalty rates are based on the specific time or day you work. Overtime triggers when you exceed specific hour limits. Shift penalties apply to defined working schedules. Casual loading compensates for lacking permanent entitlements. Allowances cover specific skills. These modifiers interact differently depending on your job. Assuming standard base pay covers all of them leaves you exposed to thousands in missing wages. There is no single, universal weekend or public holiday multiplier that applies to all Australian employees. Administrative payroll conveniences, like an above-award flat rate or an annual salary, do not overwrite your foundational statutory employment rights. Earning more than the minimum base rate on a Tuesday does not automatically mean your employer's obligations for a Sunday shift are legally fulfilled. Legal entitlement is not a static number. It is a dynamic output that requires precise inputs, meaning you have to calculate your own specific formula to verify your pay. To calculate accurately, you need a 5-step decision path. Step 1 is identifying your award. The national minimum wage isn't a universal rate table. You must locate the specific modern award or enterprise agreement covering your job, determined by intersecting variables like industry and duties. Job titles on payslips can be highly misleading and do not dictate your legal award coverage. Step 2 is finding your classification. 2 people under the exact same award can legally have different base rates depending on experience, responsibilities, or licensing. Failing to accurately pinpoint your specific award and classification guarantees that all subsequent percentage calculations will be applied to the wrong baseline number. Step 3 is confirming your employment type, introducing strict timing rules like the July 1st wage increase. This follows the first full pay period rule. A July increase doesn't take effect mid-cycle if the period began in June. The higher rate triggers after the cycle concludes. Your employment type also dictates the interaction between casual loading and penalty rates, and they do not always stack cleanly. For example, under the retail award, a casual worker's weekend rates might already incorporate their casual loading. However, this is an isolated structure for retail, not a national rule for other industries. Part-time workers face a different trap. Working outside your agreed part-time hours can trigger overtime long before you reach the standard 38-hour weekly threshold. There are also minimum engagement periods. Many awards require 2 to 3 hours of pay even if you are sent home after just 1 hour of physical work. Employment type determines both your base pay and the specific mathematical triggers for when overtime and penalties begin. Step 4 is entering your shift details. Weekend and evening penalty structures vary wildly depending on the specific award identified in Step 1, with late-night trigger points landing anywhere from 6 p.m. to 10 p.m. For public holidays, rates are not universally 250%. Furthermore, your public holiday entitlement is generally based on the state where you are based for work, not where you are temporarily located. Shift details must also include unpaid setup and closing time. Employer-mandated preparation minutes are legally compensable work that quickly compound into severe underpayment. These shift modifiers frequently collide with contractual overlays, particularly above-award flat hourly rates. This chart shows why a $35 flat rate might legally cover a standard Tuesday shift, but completely mathematically fail to cover a $60 per hour public holiday entitlement. Similarly, an annual salary does not delete penalty obligations. These are governed by contractual offsets or annualized wage arrangements. These salary arrangements require strict periodic reconciliation to ensure the total amount paid matches what the award would have generated for the actual hours worked. Any contractual convenience, whether a flat rate or an annual salary, must strictly subordinate to and be tested against the mathematical reality of your actual hours. Consider Tunde, a part-time fast food worker. Her late night and weekend shifts require exact minute-by-minute entry to calculate precise shift triggers, not rough estimates. For Lena, a casual retail employee, seeing identical hourly rates across Friday, Saturday, and Sunday is an immediate red flag for an error. Arjun is a casual worker, but his 25% casual loading does not automatically erase his distinct public holiday penalty entitlements. Alina earns a $78,000 salary. That total must be mathematically audited against her heavy weekend and overtime hours to check for legal shortfalls. Noah works 28 hours a week part-time. Depending on his agreed hours, he may still trigger overtime rates despite never hitting the 38-hour mark. And Maya is genuinely award-free. While protected by the national minimum wage, her weekend multipliers depend entirely on her specific employment contract, not a national universal law. Despite vastly different jobs and contexts, all 6 archetypes are vulnerable to the exact same failure, trusting assumptions over rigorous algorithmic calculation. Step 5 is running the data through the Fair Work Pay and Conditions tool, or PACT, the definitive compliance calculator for this system. This requires matching exact pay periods. You must input your specific classification, employment type, and shift times precisely as they occurred. Identifying an underpayment is strictly an act of historical data matching. You cannot multiply missing 2024 hours by current 2026 rates. You must use the specific historical rates that applied to that exact past pay period. Accurate wage recovery relies purely on pairing precise historical hours with precise historical algorithms, leaving no room for estimation. If the PACT numbers do not match your payslip, do not assume immediate malice. Start by organizing your data. Create a formal reconciliation table detailing the dates, hours, the correct rate, the amount paid, and the precise financial difference. Raise this discrepancy calmly with your payroll department in writing and request correction and back payment. While systemic back payments are common, the legal landscape shifted in January 2025. Intentional wage underpayment can now be prosecuted as a criminal offense. If you are a migrant worker or a visa holder, you possess the exact same minimum workplace protections as other Australians. Your visa status does not dilute your rights. Any employer response involving threats to cut your shifts or cancel your visa in retaliation for a pay inquiry is actionable adverse action, requiring immediate escalation. Execute these steps. Record actual hours, identify the correct award, confirm your classification, use PACT with historical dates, and compare results against actual payslips. Keep a copy of all records and any written employer responses. If discrepancies remain unresolved, seek help from the Fair Work Ombudsman, a union, or an employment lawyer. This information is current as of the 11th of August, 2026. Protect your time and verify your rate.